What's going on, everybody? I wanted to drop in and go over a few things. I hope everybody's weekend is going great so far. And I'm gonna talk about what I'm wearing today, which is gonna be Tom Ford Oud Wood. And we can kind of get into this. Who told you that you have to actually physically appear in court to get justice or to get redressed? Now, the reason why I want to talk about this is because there are certain people who um, they get a summons, they go straight to court, and then they wonder why the court is abridging their rights. Okay, the court's not abridging your rights. You have to understand it's you abridging your right. And the only way that you can protect your right is by having knowledge and understanding of what your rights are. That's why I made a video called "The Right the Right You Didn't Know You Had." Um, the reason why is because a person has to know what their rights are so they can enforce them properly in court and not just be putting in frivolous paper and affidavits in court and wondering why they're not getting remedy and then flare up and get mad it's the court's fault. Okay, it's not the court's fault. It's always your fault. Okay, you need to understand it's always your fault. When somebody does something to you, it's how you react to it. Okay, it's not what they did to you. It's how you react to it. And a lot of people live in what the person did to you instead of how you're going to react on what they did to you. Okay. So stop complaining about what the court's doing and what these people are doing. It's your fault. Okay. If somebody treats you bad in life, if you consistently allow it, it's your fault. Okay. So we're going to talk about court and basically why you don't need to actually physically appear in court. Um, some attorneys are going to probably say, "Oh, he's going to get you arrested." No, I'm not. I'm just reading. So to be honest, like if you can read, you can learn law. You just have to increase your comprehension skills, and you can learn it. It's very simple. So these lawyers are gaslighting you, making you think you don't know something. All right, so we're going to go to Bovier's Law Dictionary because people love Bovier's and they love, Black's Law and all this other stuff. So we'll just go into what an appearance is, keeping it simple, straight to the point. An appearance practice signifies the filing common or special bail to the action. The appearance, with all other subsequent pleadings supposed to take place in court, should, in accordance with the ancient practice, purport to be in term time. It is to be observed, however, that through the pleadings are expressed, though the pleadings are expressed as if occurring in term time, yet, in fact, much of the business is now done in periods of vacation. The appearance of the parties is no longer formally by the actual presence in court, either by themselves or their attorneys. But it must be remembered an appearance of this kind is still supposed to be, still supposed and exist in contemplation of law. The appearance is affected on the part of the defendant when B is not arrested. So they're telling you all of this stuff. So listen to what they're saying. And I know it's kind of harder because it's old lingo. It's like 1865. But listen to what I'm saying because I'm gonna bring it from 1865 and bring it in modern day parlance. Okay, by making certain formal entries in the proper office of the court. Okay, for people that don't understand, the court is a building. The court is where the clerk is where you do business, not the courtroom. Okay, the courtroom is a part of the court, but it's not the court. Okay, so expressing his appearance. So making formal entries in the proper office of the court. What do you think the proper office of the court is? The clerk's office. See, when you read this stuff, you're like, oh, that makes sense. Why am I going to court in front of a judge? So when somebody sends you this complaint with all these allegations, all you have to do is really answer them. You see what I'm saying? You don't have to appear in court, but it's how you answer them. You see? So, or in case of arrest, it may be considered as effective by giving bail to the action. See? So that's where people got putting a caution or a bond in. That's where they got it at. You know what I'm saying? So you can bind out the case, or you can use the instrument. And any when somebody presents you with the instrument, if it's incomplete, you can complete the instrument. Meaning you can do attachments to it. You can transfer traffic tickets. People gonna tell you that's not true. I'm gonna show you. I have proof. It is true. So on the part of the plaintiff, no formality expressive of appearance is observed. In general, the appearance of either party may be in person or by attorney. And when by attorney, there is supposed to be a warrant of attorney executed to the attorney by his client authorizing such appearance. What does that mean? There has to be something in the record. So if the court forces an attorney on you, you can say, yeah, I'll accept your attorney contingent to my attorneys. So that's called a conditional acceptance. So that means that as long as your attorney works on my behalf and works in the best interest of me, I'll accept him. If not, then he's just going to be here as assistant. He's not my attorney. He's here as counsel. So meaning he's just somebody that's just here so he can file motions on me on behalf of me. He's not representing me. So that's where I could relegate him down to like being a what do they call those paralegals. So we'll go now. So I've been yapping, so I'll read it again. In general, the appearance of either party may be in person or by attorney. And when by attorney, okay, I already read that, so I'm gonna go past that. Okay. But to this general rule, there are various exceptions. Persons devoid of understanding as idiots, see, as idiots, sorry, as idiots, and persons having understanding, if they are by law deprived of the capacity to appoint an attorney as a married woman, must be in person. The appearance of such persons must purport and is so entered on the record to be in person, whether in fact an attorney be employed or not. There must be an appearance in person in the following cases. First, an idiot can only appear only in person. See, an idiot can appear only in person. That means if you go to court and you appear in person, you're an idiot. It's in law. You can't make this up. So, and as a plaintiff, he may sue in person or by his next friend. Second, a married woman, when sued without her husband, should defend in person. See? So a married woman without her husband should defend in person. This is old school law. So all that myth that women couldn't vote and all this other stuff, it's a lie. It's a lie. Back in the day, women were handling business just like men were, and what they did is when a woman was married, she would lose some rights because a marriage you're considered one. You're considered to be joined. So that's where people got that from, but it's a lie. Let's see, trying to got too many tabs open as usual. If everybody does consultation, they know I always have too many tabs open. So now um, we're gonna go over why like the system is like that. But I'm gonna read a little bit more for you. Okay. So, oops. Oh man, I went up too much. There we go. Also, I wanted to bring up something in regards to an appearance. It's very serious. It's very uh, easy for us to understand that. Like everybody tells us we gotta appear, we gotta appear. Nobody ever appears correctly in court, and then they start arguing how to appear in court. So look, an appearance. Okay, so appearance. A party enters an appearance when they show up to the court in response to a service of process. Appearance isn't only a reference to physical presence in the court when required, but also to procedural compliance, filing an answer, participating in discovery, these all constitute as making an appearance. So if you file an answer, you've appeared in the court. If you file a motion for discovery, you appeared in the court. Like it or not, for all these people saying a motion grants the court jurisdiction. It doesn't. It gives the court an appearance. That's why I say a motion is for one or two reasons. A motion is to move the court forward or to stop the court. I don't know who is telling y'all the information that a motion grabs the court jurisdiction. A motion can act as an appearance. Okay? So a lot of people, I don't want to appear in that court case. Challenge jurisdiction. Always challenge jurisdiction. Okay, that's your philosophy. There are way better ways to get stuff done than that. That's just your philosophy. Okay? So look, so some people in the comment section, they always interjecting stuff, and I'm like, dude, there's many ways to get this stuff done. You don't have to hinder what people are trying to learn just because you don't know. Okay. Typically, making an appearance means that you consent to the court's exercise of personal jurisdiction over you and therefore waive your right to challenge it later. Okay. So if you answer or participate in discovery, then they're going to assume that you're waiving personal rights. So you can challenge that and you can answer it. You can still do, you can answer and still challenge personal jurisdiction of the court too. But it's a general perception if you don't that you waived. Okay, you can still answer these things and still, reserve, but it's just how you structure your motions, your pleadings, etc. Okay, this type of appearance is known as a general appearance. So you could put on a heading in your document, I'm here for special appearance. But if you're doing special appearance, then the only thing you need to challenge is jurisdiction. There's nothing else. Jurisdiction, venue, standing. That's the only thing I would challenge on that. Okay. Failure to appear after being served will result in a default judgment against the party who failed to appear. See, they didn't say you had to go in here and argue and yell. None of that. It just says you failed to appear. That's why they enter a judgment. So then what do you have to do? Appear. How can you appear? Answer. Request for discovery. See? So y'all acting like I don't know the law. Like it's people. It's amazing to me that it's lawyers in the comment section acting as if I don't know the law, and I'm very proficient in law. Just because I'm not a bar carrier. Come on, dog. As long as you can read, you should be able to figure this stuff out. Like if you sit me in a room long enough and give me enough accounting textbooks, you think I won't learn accounting? Come on, dog. That's anybody. If you sit in a room long enough, if you dribble a basketball every single day, your handles are gonna be significantly better every day. So I don't understand why people don't think that people who are not card carriers can't teach this stuff. Of course we can. If a party does not believe the court can exercise personal jurisdiction over them, but does not want to risk the possibility of a default judgment nor the risk of losing otherwise valid lack of personal jurisdiction defense, they can enter a special appearance. See? For exclusive purpose of determining jurisdiction. In federal court, there is no longer distinction between general or special appearances. However, Federal Rules of Civil Procedure 12B2 motion allows party to accomplish the same thing a special appearance would. So, look, see how simple do you guys see why I blow up sometimes and get angry in my comment section or in my videos when I'm like, dude, this stuff is really just simple. It's just taking a little bit. But then again, I had to be patient to understand that I can't get mad that people don't know what they don't know. You know what I'm saying? So, but this stuff is very simple. It just takes you deleting all of the BS on the internet and kind of sitting back and just figuring out when you're getting to a problem, how do I solve this problem? And that's the key that you need when you take that first instinct. Even if you're like, hey, over at the Winner Circle, we want to do a consultation with you, see what it is. All a person can do with a consultation, I don't care what level of success that person has had, is all they can do is give you a suggestion. Like that's why a lawyer cannot represent you, because a lawyer doesn't know your intent until you make your intent clear, and then you have an agreement that the lawyer is supposed to enforce your intent. Then you ain't got nothing to talk about. You can actually keep a lawyer in pocket if you know what you're doing. You see what I'm saying? So this is some of the stuff I'm gonna be bringing to the table. I'm gonna be bringing a lot of fire to the table for you guys. Some of this channel may be going into being automated, but I'm still gonna be here. So, with that being said, I want to thank everybody who supports this channel. I want to thank you who are viewing this channel, taking your time, because you could be anywhere in the world, but you're here. And with that being said, I thank you.